Okay, so let's get cracking. Morning all, hope you're enjoying the sunny weather, and for any of you who are watching and listening in the garden, I'm very jealous. For those of you who don't know me, I'm Lindsay Felstead. I head up the housing management team and also am co-sector head. Thanks very much for joining this session this morning. Just in terms of the housekeeping, as I've said there, if you could use the chat function if you have any technical issues, because I definitely can't help you with those, but there is somebody who can. If you've got any questions that you want me to be answering, if you could use the Q&A function and just type those in, that would be great, and I will try and answer as many as I possibly can during the presentation. If there's any that I don't get round to because we run out of time, then I will follow up with those and make sure that I do answer them. And finally, just in respect to the presentation itself, after the event, you will be sent a recording that will obviously then contain the slides, but also obviously it will have the audio so that you can go back over it if there's anything that you missed or you weren't sure about or whatever it might be. And it will also mean that you don't need to take any notes. Okay, so we are going to cover basically the things that have come about as a result of the COVID-19 situation. I'm going to go over the Act because of notices, possession proceedings, albeit I say that with a smile because we all know that they aren't happening at the moment. Therefore, we're going to go into injunctions and using those injunctions and making sure that you get full use out of them. Also committal, because they're obviously directly related to injunctions. And then I'm going to go over access, moving property and that kind of thing. I know that some people have joined from the Welsh contingent, so hello. I have said within the presentation if something doesn't apply to you, and then I've also put in what the alternative for you is as it stands. If it doesn't say anything about it being specific to England, then it will apply to you as well. Okay, so just in terms of the background, this all started with a ministerial statement that nobody should lose their home as a result of lockdown. And I think it's safe to say that none of us would think it's right for somebody to lose their home as a result of the coronavirus. That was the statement that was made, very grand, very sweeping. The Coronavirus Act was introduced, but that Act did not achieve what was set out in that very grand statement because it didn't do anything really in respect of people not losing their home. So what we then had was a practice direction, 51Z, that dealt with a stay of possession proceedings. There was also talk of a pre-action protocol, and there's still talk of a pre-action protocol, and I know that you receive my email updates and I periodically get responses back or questions back from some of you saying, have we had the protocol yet? Absolutely not. We have not had the protocol yet. I don't know when it's coming or whether it's coming. I suspect it will be coming. I think it will potentially be an amendment in respect of the income-related pre-action protocol, because that really is where the issues would be so far as coronavirus and possession is concerned. But we don't have it yet. So it's a little bit of guesswork and common sense, really, insofar as income proceedings are concerned. And I'll touch on that in a second when I get to possession. And we have also now had a subsequent amendment to the Civil Procedure Rules 55 in respect to possession proceedings to deal with the extended stay. So if we start with notices first, a temporary 3-month notice period has been introduced in respect of Section 21s, Section 8s and Section 83, and also in respect of notice to quit for Rent Act tenancies. Now, Section 21s will be covering your regular assured short-hold tenancies, but also in the main covering your starter probationary tenancies, and they would ordinarily be a 2-month notice. now that's 3 months, and Section 8 for your assured tenancies and Section 83 for your secure tenancies. I've included links there on the presentation, and I have deliberately left them in their full Word format, so that I'm conscious, because you won't be receiving this as a kind of as a PowerPoint document, that you won't be able to click on the link. So I've deliberately done it so that you'll be able to type that into your browser, and that will take you to where you need to be, and that applies for all of the links that are included in the presentation. So in terms of these notices and this 3-month notice period, that applies to all notices served between the 26th of March and the 30th of September. There was provision within the Act for that notice period to be extended to 6 months. That hasn't happened. Hopefully that will not happen, but there is that provision there. That wouldn't impact on any notices that you have already served, so it wouldn't be retrospective in the event that that was called upon. Equally, this 3-month notice period doesn't apply to notices that you had already served before the 26th of March. So if you'd served them before the 26th of March, that's absolutely fine. The normal rules would apply. And it applies to all grounds for possession. So you will be aware that when there is reliance on antisocial behaviour, so ground 14 and the equivalent ground for secure tenancies, that you are ordinarily able to give short notice, no matter what other grounds really that you are relying on. That isn't the case so far as this 3-month notice period is concerned. So if you are relying on ground 14 or the equivalent, you still have to give 3 months notice. There is also provision for the fact that this period could be extended beyond the 30th of September, but again, we don't know what that will, whether that will actually come about or not. So just a couple of practical points in respect of notices. The first one is when to serve. And I've said that because obviously the closer we get to the 30th of September, you may want to start edging your bets on there not being an extension to that period, and thinking, well, okay, I'll wait until October, because as soon as the 1st of October comes around, I'll be able to go back to doing what I was doing before and potentially issuing a notice that's just on one day. So, you know, if you're getting to August and September and you're thinking about serving notices then, as I say, you know, from a practical point of view, you might want to think, shall I just hold off? And then I won't need to do the 3 months notice. I can wait until October and just issue notice as normal. As I've said, you know, that's a tactical choice on your part. And obviously, if this period of 3 months notice is extended, then you will still have to give 3 months notice come the 1st of October, but certainly as it stands at the moment, it will expire on the 30th of September. So just bear that in mind, that you might want to be thinking about when to do that or when to hold off. There has also been a bit of talk about the fact that you could serve notice or, in fact, just not serve notice at all, issue your possession proceedings, and then when the court is dealing with them again, make an application retrospectively to dispense with a notice seeking possession. In theory, you can do that. I'm not an advocate of doing that because, to be honest, I just don't think that there is any need for it. You've got injunctions available to you, and I'll come on to injunctions shortly. But actually, bearing in mind that there's nothing you can do with the possession proceedings anyway, even if they're issued, I just don't think that a judge is going to be persuaded that there was any reason to dispense with the notice period. That's just my personal point of view, but you know, that is an option that would be available to you should you want it. So the possession proceedings themselves, the practice direction, which brought in the stay of possession proceedings, expires on the 25th of June. That was what brought in this stay of all possession proceedings, excluding trespass proceedings, and I'll come to those in a minute. Initially, that stay was for 90 days. However, as was announced pretty recently, there is a further stay which now applies until the 22nd of August inclusive, meaning that as it stands, no possession proceedings will be able to be heard until the 23rd of August. That is an amendment to the civil procedure rules because the practice direction that was brought in was temporary and expires. So after the 25th of June, that practice direction is null and void. So there is an amendment to the civil procedure rules, and I've put it there, 55.29, in case any of you technical bods want to have a look at that. And that is what is now extending the stay for proceedings. I can just see whilst I'm doing the presentation that there are some questions coming in. Could I just ask one favour? What I'll do, I'm more than happy that you put those questions in. Once I just get to the end of this possession section, I'll then go over those questions and answer them then. So feel free to submit them now, and then I'll come back to them just as soon as the possession part is done. So I've also added there that it doesn't apply to trespass proceedings. Trespass proceedings would include, for example, a claim against a failed successor. So if you have had a tenant who has passed away and there is nobody who succeeds or nobody who qualifies to succeed, but there is somebody in occupation and they won't leave, you would issue trespass proceedings against that person to get them out and to recover back possession of the property. You can still issue those proceedings and they can still be heard. It's not affected by the notice point, not least because trespassers aren't given any notice. So there's no issue whatsoever with cracking on with those types of proceedings. And the same applies if you've got, I don't know, a genuine trespasser, somebody who's just entered one of your properties and has no connection to it. You can't get the police to move them on. You could issue trespass proceedings to get that property back. One of the things that I didn't mention, sorry, about the notices on notice to quit is that it is still just a 4-week notice to quit where you are serving it because the tenant's died and you're bringing that tenancy to an end, or because you don't believe that a tenant occupies as only your principal home or that they have parted with possession. Those notices to quit remain as a 4-week notice to quit. And the same if you serve notice to quit to end a licence or anything like that, they aren't impacted by this extension. So you can serve those notices to quit in the normal way. The only thing to bear in mind if you're serving that notice to quit against somebody who you believe doesn't occupy as only a principal home or has parted with possession and what have you, is that ordinarily you would be serving a secure or assured Section 8, Section 83 notice without prejudice to that notice to quit. And of course, that notice will have to be a 3-month notice. So just bear that in mind and don't get kind of pulled into a trap of thinking, oh, it's only 4-week NTQ. If you're just going on the NTQ, that's fine. But if you are going to serve the other notice as a without prejudice notice, you'll just need to remember that that will still need to be 3 months. Possession proceedings in respect of starter tenancies. There's just a few things that are important for you to be bearing in mind. So the first one is the Section 21 expires 6 months after service. So I received a query, I think it was yesterday. Section 21s have been served at the end of last year, I think it was. Proceedings were going to be commenced, but then we had lockdown, so proceedings weren't commenced. Those notices are now beyond 6 months and have expired, meaning that a new Section 21 notice now needs to be issued. So for any of you who did serve your Section 21s but didn't then follow that through with issuing proceedings, you will just need to check whether you're still within your 6 months. And if you are, from a tactical point of view, you might just want to think about getting those proceedings issued so that you don't lose that notice. because, as I say, if you don't issue proceedings within the 6 months, the notice won't be valid anymore. Other things then to bear in mind with that is, do you need to look at extending the starter tenancy? Because of the fact that you can't issue proceedings at the moment. So for any of those tenants that you are looking at potentially failing, do you, as a precautionary measure, need to extend the tenancy? You need to check the tenancy agreement terms very carefully, just to ensure that what you don't end up with are tenancies, starter tenancies, converting, even though you didn't want them to, because you haven't done what you need to do to stop it from converting. So, most starter tenancy agreements will include things like this tenancy will not convert if we have served you with a Section 21 notice and have issued proceedings, something like that. So you just need to check, are you going to have any of those tenancies that you need to take positive action on to stop them converting to a full tenancy if you don't want them to. And then the other thing just to have a think about is whether you need to be introducing a temporary addendum to your starter tenancy policy and procedure. And I say that for practical reasons, like potentially you offer a physical appeal hearing as part of that process, but you may not be able to do that at the moment. A lot of certainly a lot of our clients are not going into offices, so wouldn't be able to hold an appeal. So again, have a think about whether there needs to be any temporary addendum that covers that point, so that maybe you move away from physical hearings, maybe you introduce that those hearings will need to be done by phone, on the papers. Do you need to look at extending your timescales? So do you need to give people longer to appeal on the basis that it's going to take them a bit longer to gather any evidence that they might need, given that agencies are all under pressure at the moment? Do you need to leave yourselves some additional time for your responses? Again, because you're not necessarily in your offices and you don't have access to everything. You don't want to get caught out by having a very strict, regimented policy and procedure dealing with starter tenancies and starter tenancy appeals and that kind of thing, and then coming unstuck later down the line because of what happened. So just have a think about whether you need to be introducing something. It doesn't necessarily need to be physically attached to your existing policy and procedure. It just needs to be accessible so that everybody in the organisation knows that there have been some temporary changes. So in practical terms, as far as possession proceedings are concerned, with the exception of trespass proceedings, no possession orders are being made, no new claims are being heard. What's happening is that you send off your papers, it is issued, and then it is immediately stayed. From a tactical point of view, if you haven't been sending your possession claims in, but you're going to want to, you might want to start doing that. Possibly there will be a queue. I don't know whether the courts are going to deal with everything in the order that it came in. I would hope that they will. But we all know that the courts were under pressure even before all of this started. So goodness knows what it's going to be like once possession is possible again. So certainly for our proceedings and our advice, we have said, get the claim sent off to the court, get it issued, and get yourselves kind of close to the front of that queue. The other thing is that one of the questions we've been asked is, will the court just automatically list it for a hearing once the stay is lifted? In an ideal world, yes, they will. And I believe that some courts will, but I am not convinced that other courts or all of the courts will have been organised enough to have kept a track of all of these proceedings that need then to be relisted. So again, certainly my advice and the approach that we will be taking is that once the stay is lifted, we will be contacting the court and asking them to get it lifted. Sarah Orchard, one of my colleagues in the team who's on the call and on the chat, attended one of the court user groups, and basically what came out of that was that the court said it is going to be pretty much up to you to be emphasising to the court that your case is urgent, that your case is ASB, and that it needs to be listed and dealt with more quickly than, for example, a rent case or, you know, whatever it might be. So I think the onus is going to be on you or your solicitors, your advisors, to be proactive in ensuring that those cases do get listed. And even during this lockdown, you know, we are seeing with the proceedings that are going ahead a really big difference in courts as to how they're handling things. So also, because obviously there's no possession orders being made, there are no warrants being executed. I've just put this little quote in here that deals with court directions on possession proceedings. So you may have some cases where you've already issued and maybe you were already working your way through directions, or there weren't directions in place, or there were directions but the time's passed. Parties can still work through those directions if they are both in agreement to do that. So what the court have said is that it makes sense to agree some directions that might come into effect once the stay is finished, or work through the directions that are already there, albeit no party can be punished for not having complied. So it is entirely voluntary. What we have noticed, and maybe this is a cynical view, but it certainly is my view, is that the solicitors who are charitable organisations, so shelter and that type of organisation, are adopting a very strict possession proceedings are stayed, we're not going to be doing any directions, let's wait, because they are very definitely just doing what is best for their client. I can think of a particular solicitor who is not from a charity organisation. I won't reveal his name. He's in Manchester and a pain in the backside, who has also taken that approach, pretty much just because he is an absolute pain. But what we've also then noticed is that the non-charity type firms are actually continuing to work through directions because they need to continue earning money and they want money to keep coming in. So they are prepared to carry on working through them because it means that they can still work. So it's a bit of a mix, but certainly if the other side are in agreement, then you can carry on working with directions. And actually, even if they aren't in agreement, there's nothing to stop you completing your directions so that at least you are ready when the time comes and the proceedings can be heard again. This is non-COVID. I've snuck this in because it's so important, and I figured it was a captive audience relating to Section 21 notices. I'm sure that you will all be aware that there was case law that brought about much discussion that dealt with the fact that if you had not given a gas safety certificate at sign-up to a tenant, you could never serve them with a Section 21 notice and have it be effective. There is a case, Clarke, I've put it on there, that came out Friday or Monday, I can't remember exactly when, but basically good news is that the Court of Appeal have now confirmed that if you didn't give your gas safety certificate at sign-up, that can be rectified. And in order to be able to proceed before you serve your Section 21 notice, you'll just need to give a copy of the valid gas certificate for the period before the tenancy was entered into, so the one that would have been valid at the time of the tenancy, and then copies of all subsequent certificates, and then you can go ahead and serve your Section 21 notice. So that is a big change and some very positive news for landlords. So a good news story to be able to add into this section. Just a couple of questions that I've been asked and the team have been asked relating to possession. Does the practice direction, which was the stay on possession proceedings, apply to unlawful sublet cases? Well, it's going to depend on whether you're relying on just a notice to quit or not. If you're relying on just a notice to quit, that somebody's parted with possession or that they've sublet, and that is therefore that they've parted with possession, so not a breach of tenancy, you're just relying on the notice to quit, then you would be able to issue those proceedings. But as I said before, if you would be serving a without prejudice notice seeking possession, you won't be able to issue them because you're going to need to wait both the 3 months for the notice seeking possession, but also for the stay on possession proceedings to be lifted. What action can be taken against unauthorised residents? So again, as I've said, trespass proceedings can still proceed. You will, in fact, sorry, just in respect to the unlawful subletting cases, you won't be able to issue off the back of the notice to quit because the proceedings that you would issue would not be trespass proceedings. So apologies for the confusion there. If you've served a notice to quit on the basis that somebody does not occupy as only a principal home or that they've parted with possession, come the expiry of the notice to quit, if you are satisfied that they are gone, they've abandoned, they are not coming back, you've done a risk assessment of all of that, you could take back possession of the property. If you were wanting to obtain a possession order, because the proceedings that you would be issuing would not be trespass proceedings, they would be former tenant holding over, that will be caught by the stay. So your choices are take back possession of the property at expiry of the notice to quit, but you'll have to weigh up the risks of doing that, or wait until the stay is lifted. And if you're going to wait until the stay is lifted, my view is that you ought to then be serving your without prejudice notice seeking possession as well. Another question that we've received a lot is, what to do when there's ongoing antisocial behaviour and you would ordinarily be issuing possession proceedings, or maybe you have already issued possession proceedings. 100% my advice is, and is going to be on the coming slides, issue injunction proceedings. So I'll come on to injunction in a second, but I'm just going to go through the chat and just see if there's any questions there that have been picked up. Debbie, I can see that you asked about orders more than 6 years old. Sarah's answered that you would need to make an application to the court. If a bailiff warrant was previously applied for, will we have to reapply for it again? No, you shouldn't, and definitely don't be paying fees again. And once you've already paid the fees, it's not your problem, it's not your fault that this has happened. If you've applied for the warrant, if it was that a date was set but it couldn't be executed, then that will just be reset. And if you've applied for the warrant but hadn't yet received a date, you will just receive a date in due course. But as with my advice in respect of possession hearings, I would be contacting the bailiffs about those and not just leaving it to chance. Sarah, I can see that you responded to that as well, so thank you. Hedging your bets, if we hedge our bets, Chris, and wait to serve in August and the stay isn't extended, would we be frowned upon for reserving in September with 1 month's notice? Oh, I like it. You would be entitled to serve a new notice. I think what you'd be having to look at is whether it's an abuse of process and whether the tenant had a legitimate expectation that proceedings were not going to start before that date. I personally would not be advising, just as a matter of course, to be taking that approach, because I think that it could give you a bit of a bad reputation, but I also just think that it might be opening up an argument about abuse of process that you really don't need to be dealing with. I would probably keep that for some, exceptional cases, as opposed to just doing it as a blanket approach. But that's actually a really good question, and one that I've not been asked before. Helen, if you've served a Section 21 notice between 2 to 3 months at the end of the tenancy, can you still go ahead with possession if you extend the end of the tenancy to comply with 3 months' notice. Well, I don't think, unless I'm misunderstanding the question, if you've served a Section 21 notice before the expiry of your starter tenancy 12-month period, it will have the effect of extending the tenancy, but you just need to check the wording of your tenancy agreement to see if it says anything about if you didn't issue proceedings. So if it does, and you won't be able to get to that point, if you like, before the stay is lifted, then I would be writing out to them to let them know that the tenancy is being extended, and or just serving them with another Section 21 notice, because if you serve them with a Section 21 notice, it will trigger the same clauses within your tenancy agreement. I hope that makes sense, Helen, but if not, feel free to clarify. Ebony, are we able to reapply to court following a breach in adjourned terms and just wait for a date, or shall we hold off on reapplying until September? So, because the proceedings are stayed, it won't be able to go anywhere, but there's no reason why you can't submit your application. I have done that, we have done that, where you're going to want to be asking for permission to enforce a suspended possession order. We've been sending those off, so feel free to send them off. Are bailiffs enforcing possession for trespass yet? I don't know is the honest answer, Claire, in the sense that the ones that we've applied for, we haven't had hearing dates for yet. But in theory, they should be doing. What I don't know from a practical point of view is whether potentially the bailiffs have been furloughed. But, you know, that wouldn't be your problem, that would be the court's problem, and they should be carrying out possession orders that have been obtained for trespass. So I think that would be a case of having to put some pressure on the court for that to happen. Ahmed, hi Ahmed. If you serve an NCQ for abandonment and want to rely solely on this, can you apply to court straight away? No, because that is the point that I was saying before, that wouldn't be trespass proceedings, that would be possession proceedings against a former tenant holding over, but you could consider the risk and think, shall we just take back possession of the property? Hi Rhianne, trespass proceedings, is this against failed successor where the person is known or person's unknown? Either. If you know the name of the person who's in occupation, you will name that person and still potentially put and persons unknown if you think there might be others who are living there, or it could be against persons unknown. It doesn't matter. You can go against either and they can be issued and dealt with now. Gina, proceedings have been issued. Oh, proceedings have been issued. Sorry, I've missed where that comes in. Proceedings have been issued and we're currently waiting a date for eviction. Are we okay in that we do not need to serve another Section 21? Yes, absolutely. You are fine. Will we be sent a copy of the slides? You will, along with the recording. And I think closure orders. Sorry, this is to do with closure orders. Do you know about a tenant's liability to pay rent during the closure period? Well, they're still liable for rent, but I can tell you now that the chances of them doing it are between 0 and 0. I'm not aware of any cases where a closure order has been obtained and a tenant continues to pay rent. What usually happens is that arrears build, and that then forms part of your possession claim along with your reliance on the mandatory ground. We've got an injunction order in place which somebody is continually breaching. I'm going to injunction order in place which the tenant is constantly breaching. The injunction may be dispensed with shortly, so we're awaiting confirmation on capacity to comply from a second site report. Any advice on starting possession? Well, I'd potentially crack on because you want to be protecting yourself, don't you? So I'd be looking at serving notice and moving forward, and then as soon as you get the site report regarding capacity, I'd be getting in there and either getting your order varied, extended, or applying for a fresh one if it expired. Okay, so I'm going to move on, because this is the key part really, is the injunctions. The stay doesn't apply to injunction proceedings, and courts are dealing with cases on a priority basis. So work that must be done is classed as priority one. Unfortunately, that covers committals, injunctions, both without notice injunctions and return hearings for injunctions, ASB injunctions, albeit not if you've issued the injunction with possession proceedings. So don't do that. I'm never really sure why you would be doing that, to be honest, because if you need the injunction, you need it quickly, and you never get a hearing for possession quickly, regardless of lockdown, but there we go. And in respect of arrest. So they're the kinds of cases that the court has to deal with. Now, in order to deal with it, we look at whether a court is open. So courts at the moment are divided into those three categories: open, staffed and suspended. I've included the link there for the status of all courts. The status is changing all the time. During the first parts of lockdown, a lot of courts were suspended. Courts are starting to open up slowly but surely. So it is always worth, if your local court is one that is currently just staffed, or maybe it's suspended, just keep your eye on it, because as I say, it's changing all the time, and you know, that might then be that it is an open court or at least a staffed court. So injunctions, antisocial behaviour. Because you can't be going for possession and obtaining a possession order, what you very definitely cannot do is say, oh well, we'll just have to leave it, we'll just have to wait. If you have got antisocial behaviour being perpetrated in your communities, you've got to deal with it. Your tenancy policy will say that that's what you do. Your ASB policy will say that that's what you do. It is not right nor fair to have people living in situations where they are scared, where their daily lives are being impacted, where their mental health is being impacted because of the fact that possession proceedings have been stayed. So 100%. And that should be your approach to injunctions all of the time anyway, but even more so now, there is no excuse for not applying for them. And what you need to be thinking about is, should your applications be without notice? Now, the courts are, what are we, 13, 14 weeks in? The courts are well used to dealing with without notice applications. I've lost count of the many that we've done, but we're up to 80 odd. I've got 3 for today and tomorrow, and that's just me out of my team of 14. So they're being done easily, quickly, frequently, and courts are ready for it. We also know which courts are not dealing with them very well. For those of you who don't know, you do not have to issue a without notice application in your local court. You can issue it out of any court. And the advantage of that is that the bigger courts, who are on the ball, who are processing, who are dealing with things really quickly, it means you can issue there. So for example, last week I had 2 without notice applications. One of them I submitted to court at 5 to 2. I got an email from the court at 20 to 3 telling me that the hearing was going to be just after 3 o'clock. Had the hearing by 3:30. I'd got my order. By 7 o'clock that night, that perpetrator was served. So, and the same, very similar for another one of the ones that I applied for last week. So you can apply to any court on the without notice basis and then have it transferred to your local court for the return hearing. Powers of arrest and exclusions are being granted. Powers of arrest, absolutely. If you're applying for without notice injunction, the test is that it is just and convenient to make the order. And, you know, even as I say that, just and convenient, you know, that's a very, very low test to have to meet. Your evidence absolutely should be able to smash that test. For powers of arrest and exclusions, the test is use or threaten use of violence and or significant risk of harm. Emphasis on the or. It does not just have to be violence cases, as I'll come to in a second. On a without notice basis, you're always going to be getting a power of arrest, because otherwise, why are you applying without notice? There's no point. So you will be getting a power of arrest on at least your violence clause, potentially on your harassment clause, and potentially on some of the other clauses, depending on what it is you're applying for and why. The court are also dealing with on-notice applications. Now, they do have to be issued and dealt with at the appropriate court, and different courts are taking longer to process them. So in some cases, we've had on-notice applications that have been dealt with in 2 weeks. In other cases, we've been waiting 6 weeks for an on-notice application. Don't forget that if you make an on-notice application and then something serious happens before you have your hearing, you can still turn that into a without notice. So let's say you've got your sealed papers from your court with your notice of hearing, you serve it on your perpetrator and they react. Okay, brilliant, bang, straight in, without notice, you get your interim protection. For practical purposes, most of these hearings, if not all of these hearings, for the types of things that I'm talking about at the moment, are being dealt with by telephone. And it is varying in the way that that is done. Some courts are requesting that you use the approved legal phone connect companies to make the arrangements, and other courts are using something called BT Meet Me, which is where the judge phones you and you make the application. Things to bear in mind when you're applying for injunctions at the moment from a practical point of view. First of all, electronic signatures. You need one. If you are going to be drafting a witness statement in your name or in one of your officers' names or teammates' name, there needs to be an electronic signature for that statement. Now, a lot of lay people, a lot of witnesses can't create an electronic signature. So what we have done is two different things. Either that witness's evidence has been incorporated in your housing management statement. So your housing management statement says, I spoke with Joe Bloggs on such and such a date, and they told me the following, and then you put in your statement what you have been told. That's one way of doing it. The other way of doing it is that you draft a statement for that witness in the same way that you ordinarily would do, that you get them to check it, they read it, they confirm that they are happy with it, that they agree with it, and you then exhibit it to your witness statement. And in both of those situations, if they are people who are prepared to come forward with both a signed statement and attend court, if necessary, you say that in your housing management statement. The courts understand, in the main, say for one idiotic judge that a colleague of mine had on Friday, they understand that you're not able to go around getting signed witness statements from people. Now, obviously, as lockdown eases, we will get to a point where it is not necessarily going to be appropriate to continue with that practice. But certainly as it stands at the moment, that is absolutely fine. So that is very definitely a good way of getting the evidence dealt with. And then your statement says that you will provide those signed statements later down the line, and also you've then got your electronic signature on your statement. Your statement does have to be signed. Another thing to be thinking about is, as part of your application, applying to dispense with personal service. So if you are applying for an injunction, the normal rules are it has to be personally served along with the copy of the injunction order that's obtained. If you make an application for that to be dispensed with, again, as it stands at the moment, the courts are agreeing to that and are agreeing that service can be effected by posting through the letterbox. So again, purely as a result of COVID and the current situation, it's not possible or meant to be that you should be that close to somebody to be able to effect personal service, and so permission is being given for service through the letterbox. So again, ask for that. Also within your order, make provision in there for how the defendant is going to give you their phone number, because you're going to need their phone number for the return hearing, and the court will expect you to provide it. So you need to include provision for that within your order, and also the consequences of the defendant not providing you with that phone number. So, for example, within our orders, it's a very clear warning at the bottom, all in bold, very detailed, provides an email address and a phone number for the defendant to use to provide their telephone number. But it also includes that if they don't do that, the order can be made at that next hearing in their absence. And it makes it very, very clear. And the judges have been really appreciative of that being incorporated. And then from a tactical point of view, think about applying for it whilst you're waiting for possession. So maybe you've got a claim that you've already issued, maybe you were waiting for a warrant to be enforced, and the problems are continuing. That having to go and get yourself an injunction order is going to be really good evidence of why possession is needed, in addition to the fact that if that order is breached, and we've had injunction orders that have been breached, it's going to open up mandatory possession for you. So, just think about it from a tactical point of view, that, you might be putting yourself in really good stead by applying for that injunction whilst you're waiting for possession. And as I've already said, you definitely can't just say, oh, well, we're waiting for possession now. Possession is in the system. You're just going to have to put up with it, because you're regulated. You have policies and procedures on dealing with antisocial behaviour. And if something goes horribly wrong for one of those complainants or victims, and you haven't looked at injunctions, then, that's not going to be good for you. There's no reason why you couldn't and shouldn't be applying for them. In terms of some examples of things, because I think that's probably what adds the meat to the bones, so that you can understand the types of orders that are being applied for. At the very beginning of lockdown, when everybody was just supposed to be at home on their own, or within their family unit and not leaving the house, then we were able to get orders very easily that covered off that scenario. Obviously, as lockdown eases, that is then more difficult, because it's more difficult to police. But examples of things that we've got have been breaching social distancing rules. This would still apply, parties and gatherings, threatening to infect somebody else. So we've had cases where somebody said, I'm going to cough on you or spit on you or whatever it might be. And you very definitely can be using the injunction proceedings for that. That might be against members of staff. It might be against neighbours, a whole mix of things. Because effectively that is it's either harassment, alarm or distress, or actually a threat of violence, depending on your perception. Threatening behaviour, well, that's a given, isn't it? Anybody behaving in threatening manner, already that would be antisocial behaviour injunction territory anyway. One of the other ones to consider is, I mentioned to you before that there doesn't have to be a use or threatened use of violence. And some of the without notice injunctions that we have applied for have been focusing on significant risk of harm. So that actually there's been no violence, there's no threats of violence, but the nature of the behaviour is having a considerable impact on somebody's mental health through persistent noise nuisance, that it causes them distress maybe because of what they're hearing or what is happening, and that they themselves are vulnerable. Quite often when you deal with litigation cases, there's a really big emphasis on the perpetrator. Does the perpetrator have a disability? Is the perpetrator vulnerable? Those kinds of things. And you assess that, and it's right, and you should be assessing that, and you have a duty to assess that. But often what happens is that you forget to carry out that same assessment on your complainants. And if somebody's mental health is being affected by the behaviour, that's serious. And that may then be significant risk of harm, which opens up your without notice application. It might be, for example, that their sleep is being disturbed by somebody in a flat playing loud music, noise, visitors, whatever it might be, and their job is such that they operate heavy machinery, or, you know, it's a high risk job or something like that. That's, again, significant risk of harm. So don't just think about these things as violence or not violence, because that doesn't need to be the approach. And the courts very definitely are used to seeing applications that are not just about use and threatened use of violence. Exclusions, we have been obtaining exclusions both from the home and excluding somebody from other people's properties. Again, that has to be fact specific. Your evidence needs to support why that is necessary. If somebody is particularly violent, you've obviously got yourself a better chance of getting an exclusion from the home. If it's excluding them from visiting somebody else's property, well, actually, at this time, it's not that difficult to obtain that. But again, you know, you need to look at the facts, and you need to make sure that your evidence supports what you are asking for. And then also restrictions on visitors. As we move out of lockdown, we're moving away from courts being happy to restrict visitors for COVID reasons. However, and as was the case with one of my applications last week, if you need to restrict visitors because of the nature of the problems that are taking place when those visitors are there, no problem with that at all. So my application last week, the evidence very definitely demonstrated that this fellow was having people round, drug-related activity, causing a disturbance. The visitors were causing a disturbance when they were there. And the interim order that I obtained was that actually he can't have any visitors to his flat, save for people acting in a professional capacity. And because the evidence supported it, the judge didn't have any difficulties with making that order. So that's just a few of the types of orders that have been obtained. If I just move on to committal, I can see that there's some questions, so again, I'll come back to those, but committal, I've already said, courts are dealing with those as priority one. Some of those hearings are being dealt with as a physical hearing. I'm in court tomorrow, physical court tomorrow, because that's a sentencing hearing for committal. And obviously, because that perpetrator is at risk of being sent to prison, it needs to be dealt with them in court. Some of those hearings are being dealt with by phone, others by video link. I've done all of those types at the moment. And again, you know, it maybe is taking the court a bit of time to just get it set up, depending on whether they've done it before, but they are doing it and dealing with it well, and they are progressing as normal, and sentencing is being done as normal. So people are still being given custodial sentences, suspended custodial sentences. Don't forget as well that committal is also a really good opportunity to be used as a bargaining tool. So if you've got somebody that really is facing the prospect of a custodial sentence, you know, you could be considering, well, if you clear off, give up your tenancy, you know, we won't take things any further. And I've put there about the usual tactical rules applying, which is what I mentioned to you before. You know, a proven breach on committal will open up mandatory possession for you. So don't be afraid to use it. And you only need one. You know, you only need one breach, albeit obviously you're going to have to assess and be happy that what you're doing is proportionate and that type of thing. Just some questions on injunctions and committals that again have come in over recent weeks. What are judges considering to be serious ASB? Hopefully I've answered that in the sense of not necessarily what you think. Yes, use or threatening use of violence is going to be serious antisocial behaviour, but something that's having an impact on somebody's mental health can also be considered serious antisocial behaviour. Threatening to give somebody COVID, domestic abuse obviously can be considered serious antisocial behaviour. So far as domestic abuse is concerned, you will need to be able to demonstrate that there is a reason that you are involved. So when you have domestic abuse situations, there are remedies available to victims through other proceedings. However, if you are receiving complaints from neighbours, maybe they can hear fighting, you know, shouting, screaming, whatever it might be, or if your property is being damaged, maybe through a fight, then that makes it your business and you can take action. So a few of the injunctions that I have done have related to cases where there has been domestic abuse. We haven't needed the evidence of the victim. We've been able to do it with other evidence and have obtained orders which, for example, have included the perpetrator being excluded from the property. Low-level nuisance and noise, DIY during lockdown, you're going to start with letters, aren't you? You know, you might need to do a letter drop to a block of flats just saying, you know, bear in mind, you might have some key workers living here who need to get their sleep, or bear in mind that people might be working from home. Could you please just, you know, be aware of that and pay attention to that and respect that? So you're always going to start with those approaches first, but if that doesn't work, then it can definitely move on to an injunction. Practicalities of undertakings. So you will know that ordinarily an undertaking is given and the defendant is asked to sign the undertaking. I've had a mix on undertakings cases. A defendant doesn't always have to sign the undertaking. If ever you look at an undertaking form, you will see at the bottom that it says, if so directed, sign the undertaking. I've had some judges who've been happy that no signature is needed, and other judges who want a signature, and therefore that is going to be listed for an in-person hearing. Okay, so that is injunctions. I can see that Sarah has been answering some questions. If I just have a quick look at what is on there, where does mental health, where does mental health come into injunctions? You've got a case where you want to stop a cousin visiting due to allegations made by a neighbour, but the tenant states that he is her only support in relation to her mental health, so I have held fire. Well, as in, you know, tenants can say a lot of things, and I don't wish to be cynical about it. You need to look at that in a little bit more detail. So in terms of support in relation to mental health and the fact that, you know, you don't need to stay in your property all of the time anymore, can the tenant not go and visit that cousin away from the property and then get the support that they need in respect of mental health? I'm not convinced about that. I'd maybe think more of it if they were providing physical care, but in terms of mental health, I think I would have thought that that could be dealt with by still seeing that person, but just not in the tenanted property. I can see that Sarah has answered actually all of those questions on there, so unless anybody's got any further questions, and obviously feel free to have a look through that chat and see what the answers and the questions were. If there's anything that's missed, then I will mop those up come the end. So just moving on to, reservice, is this one just coming in? Can letterbox service also be external letterboxes? Oof, no, I'm not keen on that. As in, can they? Well, they can if you get an order that tells you that it can be. But I'd rather have it that, you know, are you able to push it under the door, or, you know, something like that. Anything that requires effort on the part of the person to go and get the post, I'd say is a little bit harder. But then equally, you know, the court doesn't know that it's an external letterbox, does it? So I think that it would depend. Would you need to be explicit where we know it's an external letterbox? Don't ask me questions like that. I'm an officer of the court and I can't possibly do anything to mislead. Maybe you wouldn't. I think the issue would be that you could get that and you would still just say posted through the letterbox of the property. I think the issue would be if that perpetrator then says that they didn't know about it. What is likely to happen is if they're lifted for breach and that's their response, and then it transpires, oh, external letterbox, I don't go and check it, or whatever it might be, what's probably going to happen is they might get a slap across the wrist for the breach that they've done, but they will not be able to use that argument again because they 100% by that point know that they've been served and that there is an injunction order against them. So you only get to use the "I did not know about it" argument once and once only. Where you have phone numbers for tenants, I very definitely would be suggesting phone number and email. Get your alternative service to be posting through the letterbox, but phone them and email them. And if they don't answer the phone, leave them a message, send them a text message letting them know an injunction order's been made, go and check your post. So don't just see it as, oh, we got that alternative service, we don't need to do any more. Actually, give them a bell, send them an email, because all of that then absolutely goes in your favour when they say they didn't know about it, because the more that you have done, the less chance that argument would be successful. If we're trying to exclude a household member, do we need to prove that they have got somewhere else they can reside due to their current circumstances? Sarah's beat me to it, depends on the facts. An example of one of the cases that I'm applying for an order on today is somebody who's in prison at the moment. They're on remand in prison, and we're making our without notice application whilst they're in prison, because it's going to be easier to stop them coming back to the property than it is to get them out of the property once they've returned. Depends on the behaviour and how serious it is. If you know that there's somewhere else they can go, again, another case that I dealt with was stopping a boyfriend from being with their partner. We know that the boyfriend has parents that he can live with, so that was included in the evidence and then made it much easier to obtain the order. Okay, I'm going to move on to repairs because I'm conscious that time is ticking. I've just listed there what the current position is in respect of repairs, and I suspect that for all of you, you're kind of moving towards getting back to more routine repairs now anyway. I've put a link in to the guidance. Urgent repairs, anything relating to health and safety or anything like that, you've got to do it 100%. There's just no excuse for that at all. Routine repairs, I would say you need to be doing what's reasonable, and the sooner you're in a position to be getting back to doing those things, great, and carry on. I've added there for Wales that the general advice is to avoid entering a property unless the work can't be done remotely or delayed. So it is slightly different compared to the advice in England, which is if it's reasonable and it's safe, then basically you should be doing it and you should be cracking on. Gas servicing. So many queries have come in about gas servicing over the lockdown period. I've included the link there in respect of the Health and Safety Executive Guidance on gas servicing, which was last updated on the 15th. You cannot just not carry out gas servicing, 100%, you can't do it. Not least because more people are at home now than ever before, which means there's a higher risk. So you have to be carrying it out, basically. If you can't do it, it will normally, and I use that word, emphasise that word normally, be enough for you to demonstrate that you took reasonable steps to carry it out. Now, don't forget that you can apply for injunctions for gas servicing with forced access. And when I say forced access, I don't mean that you go and kick the door down. I mean that the locks are drilled, you go in, you do what you need to do, and it makes provision for you then making that property secure again. And also that you don't need to personally serve that application and order. So there's really no excuse for you not doing that. Questions that I've been asked, and I don't know if I've put them, yeah, I've put them here. So one of the kind of most popular things is that you try and get in for gas servicing, but the tenant says that they're self-isolating, they're shielding, they've got symptoms, that kind of thing. The first thing is, if they're on the self-isolating symptoms side of things, then that's maximum 14 days. So, you can make your appointment for after that 14-day period has finished. I think the NHS guidance is something like 7 days and then up to 14 days. So you could make your appointment for after the 14 days and there should be no reason why they won't let you in. The other thing is, do they have a history of not letting you in? So have you already had your build up to this point where you've been trying to get in and you've been trying to get in and you've been trying to get in with no success whatsoever. And now, again, appreciate that I'm being quite cynical, but it's very easy for someone to say, oh, I'm self-isolating or I've got symptoms, because they then just work on the basis of it can't be checked. If there's a history of lack of access, then my view is you should be carrying on and applying for your order. If somebody is shielding, they should have evidence that they have been told to shield, and therefore they could show you that. They could send you a photo on the phone, whatever it might be, or check your own records. What do you know about those individuals or that individual, and see if it marries up. You know, if you believe somebody to be a fit and well, you know, young person, no issues, no history of anything, you know, then if they say they're shielding, that's potentially not going to be right. I appreciate it's not just due to age, but just do a little bit of background work on it, because actually that's going to impact whether what you've done is enough for it to be reasonable for the access to have not been carried out. So that's what I would say in respect of those. Just looking back at some of the questions. Regularly started tenancy, can the temporary addendum regarding the appeal be now, even though the notice has already been served? Well, if you've already said it, I mean, what you could do is make the changes to your procedure and then send them a letter out that says, actually, we can't accommodate this, or wait till they submit their appeal and then tell them how it's going to need to happen. But you really need that policy in place or that procedure in place as the addendum to back you up when you're going to do that. What's your view on the approach to people previously shielding who still don't want to allow access for compliant checks after the 1st of August when the guidance for them is relaxed? God, sometimes I sound so heartless. My view is that you should be applying for an injunction. Don't forget that when you obtain this injunction for gas access, you don't just go in all guns blazing, you know, touching every surface, you know, this, that and the other. There should be a process in place. A door is opened, the tenants and you know, occupants go into another room, they close the door, you know, you go in, you've got PPE, you do what you need to do, you come out, the tenant is advised to wipe down any surfaces. Maybe it can be that you tell them what surfaces have been touched, you know, whatever it is. You put all of those things in place to mitigate all of that. So, yeah, I'm of the view that once somebody is no longer shielding, actually, you know, you then should be looking at taking the action against them if that's what you need to do to get in and carry out the access. I would rather have an application that's gone to the court that you are criticised for because the judge thinks that that's harsh and that that person was entitled to say no, and you know, you've then created an audit trail that you applied for it. And I'm not saying that the judge would say no, because I don't believe that they would, but you've then created an audit trail of what you did, so that actually if that building goes bang, you can be safe in the knowledge that you did everything that you could. That's the approach that I would take to things like that. I don't think you can afford for it to be any different. What should our approach be to noise complaints linked to children in the household, bearing in mind children are not going to school at present? Yeah, kids. I am child-free, which is probably why I'm smiling. You would need to see what the issues actually are. How old are the kids? What are the actual problems? You know, is it a case that potentially that tenant doesn't realise the impact of the noise from the children? Is it that the complainant is actually a bit too sensitive and they need to, you know, just understand that it's a struggle for families with kids at home? Maybe there'll be a few raised voices, you know, maybe they will just be making more noise. I think it's very definitely going to depend on the facts of the case as to what you should be doing about it. But you're going to start with just asking both sides to just be mindful of each other's situation, and subject to what the nature of the behaviour is, see whether there's any practical things that can be introduced to minimise the noise. Okay, moving home. So I think we're pretty much coming to the end of the presentation. Moving home, so the regulations were amended in England so that people who want to move home can. I've included the link to that there. There's the rules that go with that in terms of being safe through that process, you know, but encouraging that process to be able to continue where it's what tenants want and what people want. In Wales, as of the 22nd, which was Monday, house viewings in vacant properties and home moves are allowed. So for occupied properties, they're not allowed, okay? That would need to be virtual viewings. So again, there is that distinction between those two situations. Practicalities and practices that need to be altered as a result of the current situations. Property inspections. So can you do an online virtual viewing initially, albeit, you know, somebody is likely to want to go and inspect it for themselves, but at least that there is an online viewing, a virtual viewing, so that, you know, you can ensure that people who absolutely wouldn't be taking that property don't go any further than having seen it online. Returned keys and viewings, again, it's expected that practices will be altered to reflect the changes that need to happen there. That's going to include things like where it's an occupied property, can that household member or members leave the house whilst the viewing takes place, you know, minimum amount of people conducting the viewing, advising the household about cleaning and that kind of thing. Sign-ups. A lot of questions came in about electronic signatures. You can do electronic signatures, however, you need to think about that process carefully, and you need to ensure that you've used a process that you can clearly demonstrate that the tenancy terms and conditions were given at the same time, that all of the relevant information was given at the same time, and that it is an actual, you know, formal process as opposed to somebody sending back an email saying, yes, I want it. If you're going to do that, if you're just going to accept an email as being somebody having signed up, you need to accept the risk that goes with it, which is that they will be your tenant because you will no doubt take money from them, but they won't be obliged to comply with the terms and conditions of the tenancy, which I have to say is a pretty serious consequence. So, you know, just think very carefully about that. Mutual exchange, tons of queries on mutual exchange. This is the guidance. So go back to the guidance that was on the previous slide, and it tells you to look at the advice to the public. Spoiler alert, it's not brilliant. There's not really much in there. It basically is that people who are shielding or vulnerable or, you know, bear in mind that you might be at risk if you're going to move home. People self-isolating or diagnosed with coronavirus, no, you shouldn't be moving home. There's no change to the legislation about the 42 days and refusing consent within 42 days. But don't forget that just because you haven't given consent, it doesn't mean that the exchange can go ahead. So I was chatting with one of our clients, I think it was last week, and just reiterated that it doesn't mean consent, but actually when you're going through those applications, the ones where you know you're going to refuse consent and you can see that on the papers, well, you can deal with those, and you should still be dealing with those during the 42-day period. So then that will leave you with the other ones where maybe there needs to be a property inspection. Write out to the parties, explain the situation to them if it is that you can't go and do your inspections, and also make clear to them in that letter that if they go ahead without your consent, they will be at risk of losing their property completely because you will serve a notice to quit at the property that they actually should be living in, that they are a tenant of. So, yeah, just you know, apply that logic to it really, and then you will be absolutely fine. In terms of right to rent checks, there was a temporary policy introduced to make it easier for landlords to carry them out. So I've listed that there. You can carry out the checks over a video call. They can send you scanned documents or photographs of documents rather than originals. However, when this is over, you then have to retrospectively carry out those checks. So you need to ensure that you're marking up those files to do that, because if you don't do it and you come a cropper, you know, the onus will be on you. So you just need to make sure that you've diarised, marked up, whatever it might be, to then retrospectively carry out those checks afterwards. And then finally, just that there is a general guidance document that covers all kinds of things. It does, it works on the basis of if you're a tenant, you know, what's your situation. It then gives guidance for landlords as well. It's a decent document, actually, so if you haven't looked at it yet, do go ahead and have a look at it. And if you're getting queries from tenants, you may well find your answer in there. I've listed the link for Wales as well. I have to say that the Welsh guidance is not as thorough as the guidance for England, but nonetheless, the link is there. That's everything in terms of the presentation. I'll just have a really quick look at the questions and make sure that they have all been answered. I think Sarah has done a cracking job of going through all of those questions, actually. Oh, thanks, Tom. Debbie, is a virtual sign-up meeting evidence enough that you have been through the tenancy agreement? Yeah, I mean, it would be, but obviously you still then need that electronic signature, and I would be making sure that you keep a note of what you have done and that you read out the terms and conditions and that kind of thing, and maybe get that tenant to send you an email that says, I confirm that you read out the terms and conditions to me, or I confirm that I've read them all, or, you know, whatever, if you're doing it as a separate process. Kelly, just back to section 21s, you advised that they expire 6 months after service. At what point do you have to serve the one that you have to reissue? I'm not sure what you mean by that, but if you've served your section 21 and 6 months has passed so that it's expired, you will serve your section 21 again as a new section 1, a new section 21, just making sure that you're still following your policy and your procedure and that kind of thing. And as I say, that you've made sure that there's no issue in terms of the tenancy inadvertently converting. I don't know if that answers your question, but hopefully it does. I will go through all of that chat after today to make sure that you did all receive an answer to the questions. I hope that it's been useful. I have, for gas safety, we are applying for warrants via the magistrate's court. Would the injunction route be a quicker process? I don't know how long it's taking you in the mags, Dimple. If you tell me how long it's taking you in the mags, then I'll have a better idea. And then I'll let you know, Dimple. Hopefully that's been helpful. For those of you who know me, you will know that I try not to do legal focusing on law, but actually the practical, and that's what I've tried to do with the session today. And I hope that that's put a bit of meat to the bones. I think it's been a really confusing time for people, but more than that, actually, as you'll know, if you were receiving update emails, things were changing so quickly at the beginning, and obviously it's stabilised a little bit now, but it was a lot of information to get your heads around, and I think that actually it's not until something like this happens that you realise how many things you juggle and are responsible for, and, you know, so, you know, hopefully it's helped just by talking through it all, and you get to kind of hear about things that are happening in practice. Please make sure that you are using the injunction process. And I'm not saying that, you know, if we aren't your provider, go ahead and still do it anyway. They are so easy, so straightforward, and, you know, you really, as a responsible landlord, should be using them and making the most of them. And I promise you that if you don't really use them at the moment, once you start to use them, you're just going to go, what have we been doing? Why have we been issuing possession proceedings when we can actually go and get remedies really quickly and cheaply? And maybe it will change some of your standard processes moving forward. And I think that is everything. So you'll get the recording, you'll get the slides. I don't know whether you might receive a follow-up asking for any comments about the content and presentation. be brutal. I can take it. I can look after myself. But hopefully it's been helpful. Hopefully you have got something from it. And if there are any questions that you kind of think about afterwards and wish that you'd asked, you know what my details are. You can drop me a line and I'll come back to you as soon as I possibly can. But it's probably lunchtime. The sun is still shining, so I hope you managed to make the most. And hopefully we'll get to see you virtually or otherwise and catch up with you very soon. But thanks very much, folks. Take care.